Hello and good evening. Hi Vrinda, how are you doing?
Hi, how are you, Sonali? I'm
I'm good.
doing well, thanks to you.
No, thank you so much. That's very kind of you. Where are you joining today from?
Mumbai.
Mumbai, how lovely. Where do you practice out of Mumbai? Are you
So
from Mumbai?
I am from Mumbai, born, brought up in Mumbai, and my office is at Kalagoda.
Oh,
So
nice.
very close to the Bombay High Court.
Yeah,
So
lovely.
office is at Kalagoda, yeah.
Nice. Okay. I really like Bombay. I go there for work at times. I have friends
So
and
you are
family
not
that.
from Mumbai.
No, I'm from Calcutta.
Oh, wow.
Yeah. Have you been?
Wow. Yeah, sometimes, but that's only for social gatherings or some weddings, but not otherwise. Not got a chance to go there and explore Kolkata as such.
Yeah. Oh, you should. You should. It's a wonderful city. I think you really like
Next
it.
time when I'm there.
For
I
sure.
shall
For
reach
sure.
out to you and then you can take me around.
I can if I'm in the city. I'm in Bangalore now.
Yeah, so I think your work makes you travel quite a lot, huh?
It does. It does. I have a friend there in Bombay, so whenever I go, he's a childhood friend, so I try and crash at his place. Few months back, I was there for almost half a month, so it was a lot of
Oh,
fun.
wow.
Yeah, if I had known you, I would have kind of spoken and
100%. So next time you have to make sure that when you're in Mumbai, you reach out.
definitely, definitely. Awesome. All right. So thanks so much, Rinda, for doing this. And, this is like the third video of this series that I started called Know Your Rights Workplace Edition. It was about simplifying the law into everyday language. Yeah, because as non-lawyers or as people who don't work in the legal industry at all, law as a subject makes a lot of us very uncomfortable, nervous, because we often feel like when you're interacting with a lawyer things have gone wrong. Yeah. And even when we hear someone is speaking to a lawyer or something, we are always like, oh, okay, something's bad happened. So we have that associated feeling with it. And hence, I personally, along with myself, have known people who have almost run away from law or any legal conversations as a whole. But honestly, the kind of work that lawyers does is so beneficial and so important. I don't think we talk about it enough. And also another factor about legal is the legal language, right? I guess everyday people, non-lawyers, face a certain understanding of law when they enter into some kind of a work contract, and we see that the legal language is extremely difficult to understand and it feels almost very overwhelming. So I've seen that my friends and myself included, we have signed documents without reading, and hence today's conversation is very important with you because we're going to talk about new joinees, right? When they are, very starry-eyed and when they want to join a new organizations. They could be an intern or they could be a working professional who is very experienced also. But what are we supposed to be on the lookout for as people who are entering the workspace? What questions can be asked? What are we signing? What are we reading? And the likes of it. So, thank you again for doing this. And I'm sure that so many people here who are viewers will have the best time listening to you. I myself, I'm so excited to learn. So, thank you so much.
So as you rightly pointed out, someone just in the morning had come for signing some documents and they said, we don't understand legal language. We don't know what you're trying to say. Then I had to actually sit down and break it up for them that, okay, this means this and this means this. So it is what you pointed out is very correct that people don't understand legal language. And with the generations to come, it is going to be difficult for them to interpret, sorry to say, but basic English. I'm
Yes.
not trying to comment on a specific generation, but we are now in a different lingo. So to compel them to listen to a particular kind of language and then keep on writing the same tune, same words, same things, it's difficult for them to understand. And as the topic today is about employment and employees, it is very essential for them to know what their rights are because as we were just discussing before this started, was that employers do have an upper hand, whether we like it or not, because they are running huge entities and they need to secure themselves from any kind of adverse impact on your businesses because of an employee. Because they are not sitting there to not that I'm trying to defend them, but they are not sitting there to uh, take risks or take damages because of an act done by an employee.
Absolutely. No, fair enough. I mean, if there are people who have been on both sides of the table, we know that as an employee, we might feel very strongly about certain things. But if we start running a business and we start building a team of your own, we'll start feeling all those feelings and try to like be very protective, because at the end of the day, the business becomes the baby, and that supersedes a lot of other things, for the good and bad. Yeah.
But that's
So
the thing, no? With sorry, but with every employer who becomes an employer at some point of time as an employee,
yes, absolutely. I
so they
think
know both sides of the table.
they do, and we have seen that unfortunately a lot of times they also forget it, right? It's just like ragging in college. You forget that you were ragged and how you felt. So, and but now you're in power. Instead of stopping it, you want to escalate it further. Yeah, you feel like you have the right to kind of give it back to society in a certain sense, but you're not really
Yes,
ragging the person who ragged you. You're ragging someone who's innocent, just like you were.
true.
So potential also.
Absolutely right.
Yes. Great. So thank you again. I will quickly introduce you for the benefit of all the uh, people who don't have the fortune of knowing you professionally, but will obviously get to know you while today's session. So Vrinda, you are the founder of your own firm called VR Legal. And just for the people out here, I'm just gonna kind of introduce Vrinda. So, an advocate with a strong track record in the legal industry, Vrinda brings deep expertise in legal advisory, estate structuring, and succession planning, business structuring, legal research, ADR. With a passion for justice and strategic problem solving, she has successfully represented and provided legal assistance to their clients across diverse legal forums, negotiation, liaisoning for out of court settlement, and dispute resolution. An undergraduate from Sophia College for Women and Law College of Casey Law College, Brinda is known for her commitment to ethical practice, client-focused counsel, and attempt to attain excellence. Again, Vrinda, thank you so much for being here. All the places that you have studied out of are names that we are all aware of. So I'm getting very excited for today's conversation. We
Thank
have a
you.
bunch of questions. Yes. So we have a bunch of questions that it's kind of collected over time for this conversation. But before that, a very short disclaimer that this is not legal advice. It is a awareness session. If you have any questions related to anything that we're going to talk about today and you need personalized advice and approach, please reach out to Vrinda directly. Her contact details are on LinkedIn itself. You can just go and connect with her or take her email and stuff and speak to her directly about your problems, which is very specific to you. So treat this as an educational session, the kind of classes we should have had in school or at least sometime in college. So treat it like that. And the comments are open. You have any questions related to new joinees, formalities, documentations, all the likes, please feel free to ask away and interact with us. Yeah, are we good? Brinda, anything that I missed?
Nothing. We can proceed.
Perfect. Thank you so much. So I'd like to ask you the first question, which is that, you know, probation, right? A lot of people join and they have 2 months, 3 months, bit more also, right? So if a person is joining and they have a probation clause, what should they watch out for, and can they be let go during that period without notice?
So first, what we need to understand at this point is, Sonali, that probation is nothing but it is a compatibility test. If I have to define it in the modern times, it's a compatibility test where not just the employer, but the employee is also trying to figure out whether it is an institution that the employee is comfortable working with or not. Now, the period of 3 months to 6 months is what is a generic period in which the employer or the employee is observing, is evaluating, and is also being structured or judged at that point of time to understand whether the company has the potential to give the growth that the employee is looking for. Obviously, at the probation stage, no company is going to be putting in a lot of responsibilities or liabilities. You are not going to be burdened with a lot of responsibilities at that point of time because, as I in the beginning said, that it is more like a compatibility test. Once the company is sure that, okay, fine, we can go ahead, then the employee has the freedom to decide whether the employee wants to continue with the company or not. Because the probation period is not just in the hands of the employer, but also in the employee. So when the employee is at the probation stage, it has to make sure that they are very clear whether they are evaluating and assessing the company's potential, the company's intentions, and the policies which the company is trying to impose on the employees are rightful or not. If at any point of time during the probation period they feel that no, we are not liking the way the company is going, sometimes what happens, the company is trying to be extremely nice to you, but they do have ulterior motives, then you have to read between the lines. I know as a junior or a young employee, you are unable to do that. So you are just like, okay, fine, we'll do this, we'll complete this work. Maybe you are ready to do more working hours and everything. But as you near your probation period is coming to an end, you should evaluate these things. Now, the next question, which is connected to this, is whether you have to finish your notice period or not, or you have to serve your notice period or not, is again very subjective. Some companies have this policy that, okay, fine, within 3 months of probation, if you are leaving the company, then you have the freedom to not serve the notice period. But some companies where you are being burdened with responsibilities and liabilities, at that point of time, they may say that no, you serve the notice period, otherwise you have to pay the compensatory fees, which usually is the notice period salary that they may be drawing at for the notice period month. So it is again a very, very relative and a subjective thing. But during the probation period, the employee has to be very vigilant of all the activities that are happening around, what documents they are signing at that point of time, NDAs, because probation may only come under the employment agreement, but it is applicable to all employment related documents as well. When I say employment related documents, I'm talking about non-disclosure, non-compete. I am talking about company policies or anything you are signing which related to a client refer document that the company compels you to sign, that all forms a part of the employment agreement or the employment related agreement. So probation period plays a very, very pivotal role when it comes to an employee who is either at the beginning or the brink of its career, or at the stage when the employee is about to decide whether they want to continue with the employment or not.
Understood, understood. So they obviously have to be very careful because, like you mentioned, that it's, both the parties are assessing each other and understanding whether this is a good compatibility, something that we're going to move forward with in the future or not.
Correct.
And of course, like you mentioned, they have to be very vigilant to ensure that everything is taken care of in that sense, right?
Hmm.
Very interesting comment. We already have people commenting. So we have Himanshu is saying that what an interesting topic. I'm listening this while sending an offer letter. This is very interesting. Himanshu. So make sure that you stand right by your employees. And we have a question from one of our listeners. Christy is asking ways to deal with fear during the probation period. That's a very interesting one. Do you have any thoughts?
You're dealing with probation period is again, it's based on your performance. If you think you are not able to perform up to the company standards. See what happens when you're at probation. There is one thing each company has to follow is primarily they have to evaluate your performance at regular intervals. And just by evaluating within themselves, it's also important that the company discusses these things with the employee so that the employee also knows whether they have to go under the PIP, that is the performance improvement program, or their performance can be rectified at a preliminary stage and they can deliver better to the company. So your fear will only be when you are not able to deliver well to the company. When you are performing well and the company has no complaints against you, there is no fear that, oh, your probation period may only be your term of employment with the company. But if there's any specific fear, and if you think the company, so like some of the cases, what happens is that you are deployed with some work. And then after that time, the company realizes that, okay, fine, you are not performing up to the mark. They may ask you to rectify it within 15 days, within 20 days. But if they still feel that no, they are not, you are not able to deliver and they are not able to extract as much as they want to, then what they do is the best way for them is to stop giving you work and just wait for the probation period to come to an end. And they say, okay, now we do not want to continue with your employment and you can leave. So this is one thing you have to evaluate and interpret by yourself. If there is fear, go and speak to the manager whom you are reporting to, or also you can see how your performance is being reviewed, and then you can decide whether you have to be scared of your probation period or you're sealing through well.
Fair enough. I think one thing you mentioned that when a person is onboarded, right, and they're on a probation, a good thing to ask the manager is what will make this employment become permanent? Like, based on what are you judging me? And have some very crisp data points. So, if my performance is being evaluated, can I put that evaluation on paper? Right? Is there some number that I have to attain, or something that I have to, some target that I have to hit? So you know that it's more quantitative than qualitative in nature. Of course, behavioral wise, if you hit all the targets and your company's culture doesn't fit the kind of attitude you bring to work, that's a whole different conversation. But otherwise, if you feel like, yeah, I'm not sure, I'm fearful, then it will be good to evaluate your performances with some data sets, that hey, I was asked to do X, I did X plus one, or I was able to do X. So in your mind, you at least know that you did the best to the best of your ability.
Okay. That's one thing which we usually see in sales and marketing, where they are given set targets in the beginning of the month and their
Yes,
targets are evaluated every 15 days.
correct.
Okay. And
Yeah,
if they are not able to achieve that targets, then of course they have a different kind of discussion where again the whole performance thing comes into action. But as you rightly pointed out, it's better. So nowadays, I think most of the companies, the big entities, have this structure where you are supposed to have a timesheet, which is maybe weekly or monthly evaluated with the manager, and then the manager takes it to the hierarchy, and then the hierarchy is deciding whether the performance of the employees well enough within their expectations or not. So these things are happening. So the fear of probation period is well in control by the companies. But for the employee to be clear, it's better that you have a good communication with your team members, mainly your team leads, who are evaluating and checking your resources on daily basis.
fair enough. Fair
I
enough.
think through that you can overcome this period.
Definitely, definitely. All right, we have another question. This is a very interesting one. What is better to propose generally to an employee who is in the initial phase of their experience? Full time, contractual, or a probation to permanent arrangement? I think, Vrinda, this is right up your alley. You do a lot of work for the employers. So, Himanshu is also kind of representing the employers today.
So now it depends which arena and which area you are looking at hiring. Now, if you're looking at someone for a limited purpose, like if you're looking for someone to provide assistance only for a particular limited venture, then a contractual basis employment would be a better, which you can restrict to a venture related employment or a venture related contractual responsibility. But when it comes to probation to permanent arrangement, that is, I think that is what usually the employment contracts have, right? It's a probation to permanent arrangement. So in our fraternity, we don't have a probation period as such upfront because we are not under the employment of payroll. But we also have something called as a evaluation period or an assessment period, under which you can assess a person. So what you can do in this case, Amanchu, is maybe you can give an offer letter, you can have an arrangement with the employee, where the employee can be said that we will sign the employment agreement once your probation period is over. In that way, you are not, neither of the parties are contractually bound by each other, or not they have any obligations. The obligations are very limited. You also have the liberty to decide that, okay, fine, whether you want to have them on the complete and permanent payroll or not. So I think this is more an easier method to go further, that maybe your offer letter or an appointment letter can be exhaustive till the probation period, and after that you can decide whether you want to have them on a contractual basis or you want to have a probation to permanent basis arrangement.
Perfect. I hope that answers your question too. So keep the questions coming. I like the relevancy of this today. On this note, a quick question I wanted to ask is, Is there a difference between an offer letter and an employment letter, or are they the same, just different
No, no,
terms?
absolutely. There is quite a drastic difference, and there are key points to this. So, recently, what we have come across with offer letters and employment agreements is this, that when a employee receives an offer letter, there are three or four major points that they are taken into consideration. One is their role and designation. Two is what are they going to be remunerated with? And remuneration just doesn't mean salary. It also includes all the perquisites and allowances that they are going to get depending on the role or designation they are being employed with. Third thing is whether their job is remote, hybrid, or it is from office space. So now post-COVID, this has become a most prominent clause which is there in the off letter, because when you are working remote, maybe your housing allowance may not be required at that point of time because you are not being dislocated and relocated. But these things are taken into consideration in the offer letter. So an offer letter will also give you a brief scope of what you are going to get into, what is the expected scope of work that you are looking for. But when it comes to employment, employment agreement includes terms like your working hours, your employment role, what is the company expecting from you at the working hour stage, what is your responsibility to the company, whether you are representing things to the company right or not, what are the terms under which you are committing a breach or violating the provisions of the employment, specifically what the company is looking at when they are executing employment agreements with you or the employment related documents, as I try to put it across, is intellectual property rights, confidentiality, indemnity, and if there are any disputes, then how to resolve it. These four things are mainly why they want to get into an employment related agreement with you, is because they want to secure themselves and they also intend to secure you. If you see, if a company is genuinely looking at having bilateral contracts and not a unilateral contract, they will make sure that they are also indemnifying the employees as much as they are expecting the employee to indemnify them. Okay. Of course, there are stages where you may feel that, okay, fine, the companies are trying to be biased. And rightly so, because as we were discussing in the inception itself, that what happens is that companies are sitting at a position where they want to enjoy the power. And also they have experienced the phase of an employee. But an agreement is binding more than an offer letter. Recent cases have also happened on these lines, is that when you give an offer letter to an employee, the employee is busy doing forum shopping. So they take the offer letter to maybe three, four companies with one offer letter, and they say, okay, fine, this company has offered me with this position at this pay package. If you have something better to offer, then let's go ahead with it. These things are not control and they are not binding upon you. Whereas an employment agreement is binding upon you. Offer letter, as per the Contract Act, you can simply say offer letter is an offer and it is upon you whether you're accepting the offer or you're rejecting it.
Fair enough. Yeah, got it, got it. So, I mean, offer letter is the first step, but of course, I know that offer letters also have an expiration date. It comes up with you. We expect your
Yes.
response by so and so date, and after that, this does not stay relevant or it's no more binding. So,
It's
yeah,
usually a week's time within which you have to accept or reject the offer. So you have within 1 week, you decide whether you want to do forum shopping or you want to come back to the company.
yeah, how to like quick shopping. You're okay
Yeah.
with that. Alright. Awesome. So, speaking about offer letters and employment agreement, I'm very curious to know that like are we allowed to negotiate clauses in the employment contracts, or is it like always take it or leave it?
That's interesting. Now, this is something which is very, very relative. Why I am saying this as very, very relative is because when you're joining as a new employee or a fresher, okay, you've just come out of college and you want to be like break the ice, earn money, spend it for your benefit. At that point of time, when you are given the contract, you're like, okay, fine, I will sign it and I'm done and over with it. You don't consider the point of take it or leave it. But when you are either the company is reaching out to you, or when you are going on a very higher position. At that point of time, you have a chance to edit, amend, or modify it as per your requirements. So this is majorly what happens is this is more like a consultancy agreements that you get into instead of an employment agreement. Okay. And when you are getting into an employment agreement also at a higher position, your freedom to amend or modify the employment agreement is only very restricted. You cannot just get up from dark skin and say that, okay, fine, now I want you to edit the intellectual property right. The company will be like, no, we can't do that. Or edit the confidential obligations. The company will be like, we cannot edit it because it will then violate our core principles. Like for a tech company, you cannot get up and say that, okay, fine, I'm going to use the codes of the company to build something of my own, which is not fair for them because those codes, they have also taken years together to build it. Yeah, but certain things like maybe working hours, or maybe the probation period, or maybe the remuneration, or how you want your allowances to be paid, those things can be rectified. Um, Also, what happens at this point of time is whether the company also has rigid policies or the company has flexible policies is what you need to look into. Maybe the employment agreement may not have certain clauses which the company rules and regulations, the company policies may have. So you have to read these agreements in total to decide whether you want to take it or leave it in a whole or as a whole, or you want to take it as a separate agreement and you want to evaluate and then amend it separately.
Understood. So, like, of course, there should be some amount of fair ask as well, like you mentioned. Like, you cannot be unfair to amend the clauses. But if there is some amount of like leeway, it's better to have a conversation and figure it out. Also, know that perhaps a lot of companies will not be up to change anything or edit much.
See, that is again a very, very relative term because if the company is very rigid, I don't want to name any specific companies, but these companies which have now grown for almost 50, 60 years, they are not ready to modify their business models and their company policies just for some junior who's joining them, right? They may modify it for a key personnel who's joining the company at a managerial level. Okay. But when it comes to a new joinee is one, they are unaware of their rights. And two, they also need to figure out whether the company's policies are in sync with the employment agreement or not. Sometimes what happens is you're signing the agreement in very hunky-dory mode, and then you're like, okay, fine. Now the policies are hitting you hard.
Yeah.
Like we had a situation in one of our clients when the company had to ask the employee to leave, but they were put in a precarious situation where the employee was pregnant. And she then pondered upon the company saying that you have no right to remove me from the employment just because I'm pregnant. She took that stand instead of understanding that the company was removing you because you were not performing. So then
Hmm.
sometimes it gets difficult.
Yeah, yeah, no, yeah, yeah. That's a interesting case. Also, someone in the chat has asked, Priyanka is asking, are consultants bound by non-competes or NDAs?
Companies do try to do that. I have myself entered into a consultancy where they did try to impose it, but no, you can outrightly say that no, you cannot have a non-compete and an NDA with them. Maybe an NDA for a limited purpose, yes. You may not go out and disclose everything about the company, but a non-compete will not be fair. Like you are rendering services to maybe three pharmaceutical companies or four tech companies, all four having maybe similar businesses, not identical, but similar business lines. Then you cannot say that, okay, fine, because I am tied up with one company under the NDA or a non-compete, I will not be able to do this business with another company. So
Right.
these things have to be made clear at the preliminary stage when you are discussing, I mean, when you are entering into contracts that no, I will not be doing this.
Yeah,
Because as consultants, you are acting for a lot of companies, maybe similar business lines or different business lines. So you can outrightly say no.
fair enough. Fair enough. On this note, there's a related question, which is, If I build something on my own time, can the company claim ownership because of the NDA? Does that happen?
So, yes. So this doesn't come under the NDAs clause, but it mostly comes under the employment related documents. See, understand one thing, non-disclosure is only and only pertaining to intellectual property rights and confidential obligations. Now, there we have this term which we use for employment as well as for NDA, which is called work for hire. Work for hire simply means that whatever work you're doing during your employment, during your working hours. Some companies also say that when you are in an employment, irrespective of whether you are working at the company or you're working outside the company, you have access to company data. Therefore, whatever work you are building, it will be work for hire. So it does restrict you from having ownership on the on the work. What you can do is there are three, four provisos to it, or you can see there are caveats or there are covenants which can help you exit this clause easily, or you can have a recourse is one, you can have a written understanding or communication with the company management or the HR. You can point it out to the HR. And the HR can then discuss it with the management and take it further that, okay, fine, this person wants to build something out of the blue and they do not want to do it in the association with the company. So then the management will discuss it with you. If the management wants rights, then you can have an exclusive contract with them and say that, okay, fine, if you want this to be yours, then you pay me extra. That is one way of looking at it. The other is if the company is saying that no, this is work for hire, then at that point of time, you can also ask the company that, okay, fine, I want to, if this is work for hire, I want to build this outside office hours, and then you will not restrict me. You can have this in writing with an email. And you also make sure that you have a, particular clause in that where you can say that you have the liberty to publish this as your independent work. This has nothing to do with your employment, and I'm independent to do this thing. But make sure that this is in writing. This is a trail to create evidence. And you also are sure that, okay, fine, if the employer is trying to build up their business with your intellectual, then you can also challenge it basis this writing with the company. So
Understood.
make sure that these things, whenever you're having any kind of communication with your employer or the company, make sure you have it in writing. So you are also secured in your position, and the company also cannot challenge and tell you that, okay, fine, now this is our work because this comes under work for hire. So make
Right.
sure these communications are put across properly and in writing.
So work.
Usually these,
Sorry, please
sorry.
go ahead. Go ahead.
Usually, these clauses are supported with caveats like, okay, in written, if the employee obtains written consent from the company, then the employee has freedom to do this. So the employee has to exercise the right that they are conferred under these clauses.
Understood. Understood. So, another person here is asking if people want to negotiate for certain terms which are not mentioned in offer letter, and the recruiter says we will manage once you join. How can a candidate check for what the company policies or norms are?
So when you receive the employment agreement, you
Hmm.
will have a vague idea what the company policies are. Okay. If not, so what you can do is when you receive the offer letter, you can respond saying that we will execute the offer letter or we will confirm the offer letter subject to you giving us review of your company related policies. Usually the companies don't do that. They will only share with you maybe the company employment agreement or the non-disclosure agreement, but you can explicitly demand that, okay, fine, you want us to join. But what happens is, sorry, I'm just trying to interrupt this thing, but what happens is when a fresher is joining, no, they don't take them very easily. But when these things are asked by a senior person or an experienced person, at that point of time, they are compelled to show because they are also in dire need of that person joining. So they will disclose these terms and policies, and at that point of time, you can negotiate with them that, okay, fine, these are your policies which are going to contradict with our current employment. So it is better that you can rectify it at this stage.
Fair enough. Fair enough.
So
Um,
you can demand for policies upon the execution of offer letter, but make sure you communicate it well.
Fair enough. Okay, great. So great. That is a good learning. I also did not know that you can actually ask for the policies even while you get the offer
See,
letter.
ideally, you know what, these things all arise from your employment related documents. But if now you have to understand one thing, we are looking for both kind of employees. One, we are looking at fresh recruits and we are looking at experienced recruits. The experienced recruits always have an upper hand because the company is in desperate need to hire them. That is why they are hiring them. So they have the freedom to ask it. The fresh recruits at this point of time are looking at that we need an opportunity. We are therefore approaching you. Then they are not that confident that, okay, fine, we can demand for all these things. So there is
Okay,
a difference between a fresh recruit and an experienced recruit.
fair enough. Fair enough. So I think this is in continuation with the NDA for contractors question. What if a consultant ends up signing an agreement in which a non-compete is added? Can it be in effect once the consultant leaves the organization?
That completely depends on your non-compete agreement, the clause. If the non-compete clause, usually these companies and consultancy agreements keep it for 3 years to 5 years. They try to cover as much as period that they can. Okay, so it is very, very relative and subjective that whether you are having the liberty to not follow the non-compete clause after termination of the consultancy agreement. But that completely depends on what kind of agreement you have signed with the counterparty.
Understood. And like, can it be challenged later? Is that something that can be done, or once you've signed, we got to
How are
adhere?
you going to challenge it is only if you say that you were coerced into it. And proving that you were coerced into it is very difficult because when you are getting into a consultancy agreement, anyone and everyone is ensuring that they read the contract. Nobody is going to blindly sign into it. So the company will have an upper hand when it comes to non-compete clauses or non-solicitation clauses.
Understood. Understood. This is a very interesting question. I think you'll like this one, Vrinda. We are a very mixed crowd today. So, in a work from home setup, how can we legally ensure that the full time employees don't take on freelance work related to the role for which we have hired them?
That depends if you're giving them devices from the company. One is one of the areas where how you can control the freelance work is that you can provide them with devices and equipments of the company and then you can monitor it. Most of the tech companies, most of the startup techs that are employing or hiring people make sure that their devices are sent across. Now, further to be vigilant on it, I find it very difficult that you will have any chance of telling them that, okay, fine, you cannot do freelancing job. And how are you going to control it? Today, you may say that, okay, fine, the employees coming to work Monday to Friday, Saturday, Sunday, they still have the time. It's only when you figure out that, oh, they have started reaching out to people who are providing you similar businesses. At that point of time, you can say, okay, fine, you violated the terms. But otherwise, it's extremely difficult. So there is no way you can track unless you start putting some audio uh, clips or you have some kind of technology which can record that, okay, fine, they're doing freelance jobs. But then you are again violating the privacy, so which is not right. So I wouldn't advise to do any such kind of things where you violate their privacy. But I think you can have an explicit conversation with them that we would prefer that you do not have these kind of do not indulge into these kind of activities and only
Yeah.
perform for the company.
Yeah. So, you are actually letting them know that moonlighting or freelancing is not allowed. So, it should be in writing in a certain sense.
Hmm.
Yeah.
Moonlighting, I think there was a recent case of Wipro and Infosys also, which had come into light with regards to moonlighting one employee doing seven
Yeah.
simultaneous freelancing jobs, which came out and it became like a big conversation. Sorry, I don't mean to
No, 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 no. It is.
include any of the company names, but these were public information, so they're not confidential information.
Yeah.
But yeah, I think it is better that you have a conversation with your employee at that point of time, whether it's a work from home setup or whether the employee is coming to the work place. In either case, they have the liberty to take up work. So it's better you communicate to them. I
Yeah,
think
fair
that
enough.
will help.
Yeah, nowadays freelancing has become very common. So if that is the norm of your organization, it's better to have that conversation so you know that is this the right person for you or not, and you're moving forward with complete clarity instead of always wondering is this person freelancing or can they be trusted or not.
Correct. Also, Himanshu, what you can like, because this question's coming from Himanshu, I would like to just point out that you can maybe, if you want to give that freedom to your employee and say that, okay, fine, don't do freelancing jobs with our clients. You are free to take up jobs with your independent people that are not common between our parties. That is one way to make them feel more comfortable when it's a work from home setup. I'm not saying that this has to be a mandatory clause in your business or your employment, but you can surely have this with them when you want them to um, have a friendly relationship with you, where you can say that do not try to solicit my employees, but my clients or my employees, but you are free to take up work on your own.
Fair enough. I think Manshi is like following up on this. We don't intend to do this just to make sure that the work is not getting hampered. Okay, fair enough.
So that I understand. And most of the companies have this concern with them. So that is why their policies are kind of lingering around strict, rigid um, terms. But I think an open conversation will always help.
Definitely, definitely. This is another one. For experienced recruits, when a recruiter approaches, they ask for notice period and current or expected CTC, but don't diverge their salary range. If they share the range, they mention that it doesn't matter as they won't pay more than 30% of, I'm reading from it, of current, even though their lower range is much more. If candidate is good fit and experienced, how can they challenge this?
Now, if the experience matters, and this is a very, very generic answer, do not take it as a solicited or unsolicited advice. But if you really want to hire that employee, then you have to have that understanding that they are always going to quote higher than what they are expecting. And they are always going to show that their previous CTC was 10 times of what you're paying them. So to have a discussion with them, you can offer them that, okay, fine, we can offer you this CTC, and maybe in next 6 months we can evaluate and come back to you. That is one way of doing it. The other way you can have is that, okay, fine. So basically, I came across one business model where it was, we are going to be me give you a base price of base salary of this or a base CTC of this, and each work that you deliver, we will give you a proportionate share. That is how you can have your discussion with the employee that you are in dire need to hire. But this notice period thing or discussion with regards to their lower range or high range is again very generic. I do not wish to answer this thing on this platform because it will be again targeted in a different manner.
Sure, definitely. So I think like very specific questions can definitely Vrinda can take it up one on one. You can chat with her on LinkedIn and then get her email ID and take the conversation forward. But
Thank you,
I like
Sonali.
of course, of course. And also, there's a very big disclaimer. None of this is legal advice. Please take it as an awareness session. Like, nobody can possibly talk about their problems or legal, I would say, issues at the point of time on social media so explicitly. So I'm sure everybody here is also texting with some layer of confidentiality. So at the end of the day, Vrinda is only able to answer as much as you are able to share. So for any specific queries, please reach out to her and get the issue sorted. All right, interesting. We want to move ahead a little bit again. NDA happens to be a very interesting one. Can the NDA stop me from reporting harassment or toxic behavior publicly or legally? Is there something like that?
Now, NDAs doesn't NDAs. We need to understand one thing at this point is non-disclosure is only and only limited to intellectual property rights, to confidential obligations, and the confidentiality or proprietary rights. This comes more under company policies, more under employment related agreements, and more under how a business model is functioning. So at this point of time, we need to first do when a person is harassed or a person is suffering because of toxic work environment. And toxic and harassment cannot just be limited or restricted to physical. It also leads to mental harassment. It also leads to physical harassment. Physical maybe only when a person is doing work from a workplace. Sometimes we also come across a situation when a person is going on site of a company site, like if you are representing your employer at your client office, there also, if you're facing harassment, the first thing you are supposed to do is reach out to the human resources team of your company, explain them the entire situation. The first thing the human resources team will say that, okay, fine, stop going to their office. Or if it is happening in their own office spaces, or it is happening over online conversation when you're working from home, then you can reach out to them and say that this is what is happening with me. Report it in writing on an email. After you address an email, send it to them. Ask them to take an action within, say, 5 reasonable days or 7 reasonable days. I think 5 reasonable days are more than enough because 5 business days are sufficient enough to make a decision. If the human resources team is not performing as per your expectations, then you can reach out to them and say that, okay, fine, we will reach out to the company management. You can follow up once more after addressing an email, but if the human resources team has been negligent or they are occupied, I would not say negligent in the beginning itself, but if they are occupied with some kind of company commitments, then you can reach out to the company management, maybe 1%, 2%, or the entire board, and draw the attention to what is happening with you, and you addressed an email to the HR team. And if the HR is not taking action and the company management is pushed, then maybe the HR will take up onus of delivering what they are supposed to. If the company management is not able to take up that thing, and the company management also, again, as I previously said, that you have to give it to them in writing. Similarly, you are supposed to give the company management in writing. So you are creating a trail with the hierarchy. Once you are done with that, you can then go out publicly and say, or you can file an FIR if there isn't physical or in, you can't go for mental and emotional for to police recourse. But for a physical harassment or some kind of modesty being unraveled by any of the company employees, then you can reach out, and you can also reach out on the public platforms and say, well, this is what happened with you. Ideally, when there is uh, POSH, you have something prevention of sexual harassment in the workplace. Then you have POSH. POSH is compelled to take action against these illicit behaviors. But if these things are not in place, then you have the freedom. The NDA does not restrict you from going public and speaking about the harassment you faced at workplace. It could also include toxic workplace behavior, and it could also include harassment, mental harassment, and emotional harassment. If then the company is bringing NDAs on platform, you have absolute trail records and you have the evidence to prove that, okay, fine, I reached out to you, I reached out to the HR, I reached out to respective people. No action was taken, hence I was compelled to go further and take appropriate action against you.
Understood. Fair enough. Fair enough. No,
So
this
the
is this.
NDAs do not restrict you. Company policies may, employment may, but NDAs do not restrict you.
Understood. Understood. Here's another question related to the NDA. So there's a lot of information online that says non-competes are not legally binding. Wanted to understand what the law is with regard to that. If it is part of the agreement and it is signed, then does that mean that it is legally binding?
So if you are aware of the recent judgment of Daffodil Technologies, which is passed by Delhi High Court, which has got a complete backlash on the clause of non-compete and non-solicitation, where people, the tech companies used to recourse to non-compete clauses or non-solicitation and non-disclosure clauses. But now non-compete I don't know why this non-compete thing has got so much of weightage. Non-compete is only for a limited period. Nobody's restricting you to enter into a non-compete for indefinite period. If it's for 1 year, then you can say that, okay, fine, for 1 year, I will not do this kind of job. But that is absolute liberty. Maybe at the time of notice period or at the time of termination or when you are just finishing your consultancy agreement, at that point of time, you can say that maybe you can ask the employee that I want to work with a competitor. You can consider it that because we have a long association of business, I ensure and I undertake that I will not reveal your intellectual property rights information. I will not reveal your confidential and confidentiality clauses, but I need to have the freedom to be employed with a company which may not be, sometimes they are not direct competitors, sometimes they are indirect competitors. So at that point of time, you can inform and discuss these clauses at an exit and full and final settlement that, okay, fine, now I'm done with this. I want to exit. If a competitor approaches me within 6 months of me terminating the employment or me resigning from the employment, then at that point of time, you can have these points of discussion with the company and say that, okay, fine, now I need to leave. And now I need the freedom to join the competitor.
Okay. Okay. But
See,
the
sometimes what happens is we are just very hesitant to reach out to the employers. Sometimes they are open to discussion, sometimes they may be rigid. You should always try your luck and reach out to them, and maybe you give them that confidence. Okay, fine. I am not going to reveal this information. If I reveal this information, then maybe you have the liberty to do that. But with this Delhi High Court judgment, I think we are right now caught in a situation where we cannot impose on the compete and non-solicitation that easily unless there is an appeal and there is an order which is adverse to what has been passed right now.
okay. So is it like the I think the whole point we're trying to get at is like, is there a legal binding? Like, if the non-compete is there and people have signed it, does it mean that you have to abide by it for whatever 1 year or 2 year?
Yes.
You got to do that.
You
Oh,
do not see because also understand one thing, the binding is on the companies impose these clauses mainly and mainly to secure their codes, to secure the intellectual information and confidential information. Rest of the things are available on public platforms. They are available on public entities when they have their websites. It's all out. So there's nothing that they're restricting. The restriction to non-compete is only so that their information, which is confidential and intellectual, should not be passed on to a competitive business.
right. Okay. Okay. Understood. All right. So we're at the fag end of the session. I'll just pick up a few questions. Everyone, like I said, we are live on LinkedIn. If you want to put your comments or questions here, we have perhaps 5 6 minutes. Try to keep it crisp to the point, and something that can be answered by Vrinda, which is not extremely specific to your case. Also, this is a public platform. This is not a legal advice. Only an awareness session. Do not forget that. All right. Okay, I'm gonna quickly pick up something perhaps that I think it's this is an interesting one. So, what are my rights if a policy feels unfair, like dress code, social media usage, or availability hours? And this has been a problem in the recent times where dress codes have been in the whole discussion. Can I use social media? Can I not? Should I be available beyond work hours as well? So, is this something we can do?
With the evolving employment dynamics, I would rather put it this way. We all know, like the generations that are coming into the industry now, they are explicitly clear. We are not available after working hours. We will wear what we want to, and we will use social media for our comfort. Like I was coming across some, maybe I don't want to comment platforms, but I was coming across some articles which were really hard hitting. And I'm not targeting any particular generation. Please do not take it that I'm targeting any generation. We need to understand that dress code does not mean that you are supposed to wear school uniforms. When we are saying dress codes, we are basically And I'm not here to define what is decent dress code and what is indecent dress code. All I'm here defining is that dress codes only just only ensure that a company follows a particular system. Now, if you are, and there is going to be enough moral policing for this thing that okay, fine, this is the right dress code and this is the wrong dress code. Like when I'm working with startup companies, their dress codes are very different than a corporate setup. A corporate setup, you cannot wear a t-shirt and a loose jeans and say that okay, fine, this is my dress code. But you can comfortably do that with a startup. So when you think a policy is unfair, when you need to understand that whether what sector you're working in. If you are expecting that a corporate setup is going to allow you to wear denims and t-shirts every day, big size, oversized t-shirts to work, they are not going to do that. Now, today, if I sit in a tank top to a law firm, they will be like, okay, fine, she's not serious about work. So, dress code only give you a streaming or a line of discipline to come to work in a particular setup. But yes, if they are telling you that no, you're only supposed to wear Indian or you're only supposed to wear skirts to work, which are very revealing, then of course you can say that, okay, fine, this is very unfair. Because not everybody is confident of wearing a particular kind of an outfit. That can be treated as an unfair dress code. Coming to the second point is usage of social media. Now, how much are you going to restrict and how much are you going to allow someone to use social media is very, very subjective. If you're working in the social media area or like a social media marketing or a social media platform, then you cannot say that, oh, you cannot use social media. But when you working at a corporate setup and they have strict timeline, and if they are telling you that do not use social media at these hours, some of the companies I know also have like some jammers where you cannot access social media at all. Then at that point of time, you can say that these are your entertainment. See, like when you have lunch hours, you cannot say that okay, fine, you cannot use Instagram. Or when you are out for a tea break or a smoke break, you are going to access it. You cannot say, huh, you can have a limitation or restriction, but then again, people will be like, okay, fine, this is violating my privacy, this is violating my independence, freedom of speech, expression, and then it becomes unfair. So I think there has to be a equilibrium, there has to be a balance, and all corporates as well as employees have to understand that you are reaching out to the company for work and the company is expecting you to do some work. So I think that equilibrium is important. Availability of hours. I am absolutely of the view that once you are out of office, you should not be working. But that is only applicable for employees. You see, most of the European countries, they have now they are coming up with 4-day working policy. In a lot of these American companies also, you work for 4 5 days, or you deliver 40 hours of work weekly, and the employers are not allowed to reach out to you after that. So I think this policy sooner or later will come to India. Right now, I know we have a different kind of policy which is in controversy, but sooner or later, this controversy also shall become smoke and thin air, and we will have a 4-day work policy. But that's only applicable to employees. I don't think so. Employers have the comfort of not working on after working hours or not working on weekends.
Right.
So
We're
Nani
gonna
will
just
agree to this.
I will. I am not a fond, not fond of restricting people in any way. I also feel because you have very rebellious kids, right? In school, or if you're a parent and you have more than one kid, you'll know that you'll have one rebellious kid, and the more you tell that person not to do something, they're gonna find sneaky ways to not only do it way more than was allowed, and find ways for you to never find out. So it's only gonna eat you in your head.
And they'll also instigate others to do it. So it's
Yeah,
better that you do not have unreasonable policies. You have more friendly policies, but make sure that there is a balance to everything.
sure, sure. This is a very Himanshu has a very interesting question. Uh, how question is generally asked on the timings. However, being a startup, work doesn't come with a 6 to 10 timeline. Obviously, we are not mentioning here take late night tasks. How should these questions be mentioned in the offer letter so that there is a scope for flexibility, yet maintaining their privacy?
No workplace works from 10 to 6, Manchu. No workplace. I wish we all had workplaces where we could say 10 to 6. But what you can have is this, that you can offer your employee that, okay, fine. There are going to be hours where you are expected to work more than the expected timelines or the expected working hours. But you can also compensate them with, maybe if they are expected to wait or work till late hours, you can say that, okay, fine, we'll ensure that you reach home safely. We'll provide you with those provisions. Also, you can provide them with compensatory offers or compensatory leaves where work is not hindered, but at the same time, they also have the comfort of saying that, fine, I enjoy working with them because they are also considerate and reasonable to their employees. If we are working, say, from 9 o'clock in the morning to 9 at night, and the next 2, 3, 4 days, because you have deadlines and you have deliverables to be rendered at that point of time. On the fourth day, maybe you can be a little kinder to your employees and a little helpful and tell them, okay, fine, you can take a day off, you can ease it out, and come back fresh next day. I think that is one way of helping your employees also enjoy the work that they are doing with you. The other way is that if you are making benefit out of your business, then you can also say that, okay, fine, if you deliver extra hours or you work with us for more than your expected working hours, then we may compensate you or we may give you an additional benefit, which may be monetary or it could be in kind. So it is very individual decision that you're making at this point. And I think you can make it easier for your company employees.
Yes, fair enough. So I think I do agree with all of that. I guess having a very candid conversation to tell the employees that, hey, sometimes we have crazy hours and, startup culture, the moment people join, they are aware of it in a certain sense that processes are not set in place. There's a lot of stealth building that's happening, or the hustle culture is very predominant there. But at the same time, we take care of our employees. We'll give you a compensatory off, or we'll give you some incentives for working extra hours, and we'll make sure that unfair practices are not happening. So employees will also kind of be loyal and honest with their work and not try to smart work around it, because or not work with hate towards the organization, feeling that, hey, they're just taking advantage of us, and the moment they get a better offer, they're just gonna run for their lives.
So a lot of these things happen, and recently I've come across that when an employee is dedicated with the company, I've seen that the company actually are offering them ESOPs or they are offering them with commissions. So like for marketing and sales team, they are offering them commissions. If you achieve your target, you will get this proportion to the money that we are receiving. You're going to get a commission to this account. So that way you are also driven to deliver, and you are also feel that, okay, fine, if the company is giving us a share in their business, ESOPs are nothing but they are share in the business, then they also are driven to deliver a little more, a little better, and they feel more homely when they are when they are employed with you.
Yes, and you're giving them a reason to have ownership and accountability. Why to kind
Correct.
of, be a school teacher or a strict parent when you know that, hey, boss, if you do this, you're gonna get this, and that is only beneficial not just for us but for you as well. You tend to earn something. You can use the comp ops for a different time when you actually need leaves and you might not have any. So all of that, when they understand the value proposition, most people will be okay to trade their skill and talent and time for whatever they're supposed to get extra. I think the problem happens when employees feel that I am getting paid whatever I'm getting paid, but I'm giving way more value, or the value is getting extracted out of me forcefully without me wanting to work for so many hours. But because I cannot do anything, I'm stuck here. That's not a
So a
great thing
lot
to.
of companies, now that you're pointing this thing out, now a lot of companies that I know of, sorry, I'm taking a little more time, but a lot of companies I know of, they what they do is they have these um, group discussions, or they have these meetings with your key personals or key managerial personals where they discuss whether, and they evaluate, the management basically evaluates whether the employee is keen on continuing work or they are not keen on continuing work, whether what is your contribution to the work and how are they looking up on to moving further. So these things help the company also decide whether the employee is performing for the company or they are just building their bridges and then they'll move out when they feel that they are no more of achieving their growth. That is one area that they are looking at. So it is for, I won't say that it should only be the employee's responsibility. It should be the company's responsibility equally to make sure that the employee feels comfortable with the company. You cannot just keep on bombarding them with work and not never appreciate the same thing. That's extremely, I think, insensitive and inhuman.
Absolutely. Yeah, I think which is where the culture of the company makes a lot of difference. And if the manager can make a world of a difference. And if you have a smaller team, a founder led team, attaching the person's talent KRA designation to the purpose of the company really helps. Like if the founder is having a smaller team of 20-25 people and they're able to tell the people that, hey, this is why I built the company, this is what it means to me, and this is how it can affect people, other people in the long run, or this is how, as a company, we are doing something good for the world. The employees also feel that, hey, okay, I also want to work for this purpose beyond just the money or the profits. And there again, you can build that trust and then loyalty within them. But like Vrinda, you mentioned, at the end of the day, at the crux of it, if you look at your team like a resource or a number on a timesheet, your approach is going to be very different. And you, if you look at people as people, you want to retain and you want to build that long term commitment with, you're going to treat that person very differently from a very different corner of your heart and your brain.
Correct.
Perfect. All right, we have some good thoughts from Himanshu. Thanks a lot. He's saying it's a fantastic session and he's completed the offer letter, it seems.
Congratulations.
Well, it's exciting. Okay, we're actually a bit beyond time. Thank you so much, Rinda. I know you were, like I was mentioning, sometimes, I hear crickets. So I'm only discussing with my guests, but sometimes people are extremely active and they're bombarding things and questions. And I'm happy that today was one of those cases.
I really enjoyed this whole conversation. It was more like a conversation than an interview, I would put it this way. And it's really nice you reached out, and the topic is one thing I really enjoy on working. And so when I think when we were discussing in the beginning, I said that I usually work for the employer. So my perspective is different, but when you raise these questions, you realize that no, it has to be a fair deal for both the parties. You cannot always have just one side of the conversation where only the employer has an upper hand and the employee is suffering. So,
Absolutely.
and I have always put this across to practice that the contract has to be bilateral and it cannot be unilateral.
Appreciate it. Thank you so much for doing all the wonderful work you're doing. I think even as a legal advisor and as a lawyer, when companies come to you, if you are also able to tell the companies that, hey, this looks a little unfair, then that makes a world of a difference, because you're at the crux of it, you're kind of tweaking certain things so that doesn't even reach the employee where they feel that, oh, I don't know how to raise this, but I really need the job. You're doing a lot of work behind the scenes for the people who are able to join companies with policies and practices that are fair both ends, because someone like you has done the job. So thank you so much for doing that.
Thank you.
Right. Awesome. People, I hope you enjoyed the conversation. Please get in touch with Vrinda for all your other questions. Please ensure that when the conversation with Vrinda happens, it is not going to be a social media conversation like this. That is going to be a professional advice, a professional conversation. So please approach it with that mindset. Don't be like, hey, I saw you speak at a LinkedIn Live event, so I'm going to just continue the conversation, right? At the end of the day, she is a professional and it's only fair. We're talking about a lot of fairness today, that you reach out with the right intent, and no favors given at all. This session, you can rewatch it if you want to multiple times. Reach out to her for your legal advice and anything. Linda, any closing thoughts, anything at all?
I much appreciate that you pointed out that whatever advice is going to be a legal advice and not a professional friendly advice. That's very important because then people just reach out to you in a very casual manner. At conclusion, I would only like to say that I understand for people, privacy has become a very, very um, important thing rather than it is not, it's no more like a adjective that we used to use. And people need to understand that voicing out your points, voicing out your opinions, and when I'm talking about people, I'm talking about employer, employee, both the sides. It is essential and it is very important that you understand both sides. You also need to have an open ear. It cannot be that the employers keep on bombarding their thoughts, their policies. They have to understand, they have to interact. They need to have the town halls more. They need to have town hall discussions more with their employees to understand where the company is lacking. And the employee also needs to understand that the company is not just working for their own benefit, they are also working for the employee's benefit, because ultimately your remuneration is going to come from the company's corpus. So strict policies, strict beginnings are essential, but also at the same time, we need to have flexibility. We need to have a little more polite and humble approach to our employees so that they feel comfortable reaching out to you.
Fair enough. Absolutely fair enough. Also, like in the on the topic of town halls, please make them a two-way conversation. I've heard a lot of town halls are just like PPT throwing and just like we have done this, we have done that, or we have not done this. Then how do you get the pulse of the people if you're not hearing them out? So yeah, thank you so much. We're receiving a lot of wonderful comments. I'm gonna just quickly put them up on the screen as well. Thanks, Vrinda, for doing this. So, on that note, this brings us to the end of our wonderful conversation today. Thank you so much for your time, Vrinda, and of course, for sharing your expertise with us. And like
Thank
I
you so
mentioned,
much for having me.
of
Yeah,
course,
it's really a pleasure working with you on this particular topic. And it was quite insightful for me also, because when people throw questions at you, you are like, okay, fine, there is a way to look at things.
absolutely. I'm very glad that we did this. And when you're in Bangalore, coffee is on me. And when I'm in
Mumbai,
Bombay, yes, Mumbai, we'll catch up and do something fun as well.
100%. 100%. Thank you so much.
Thank you
Thank
so
you,
much.
Sonali.
Bye bye.
Bye bye. Bye.